Welcome to Sriram's IAS. Today's topic for discussion is removal of the Judge of Supreme Court. So, Constitution Article 124 to 147 Part 5 deals with the organization, independence, powers, jurisdiction and procedures so on of the Supreme Court. Okay. So, Article 124 to 147 Part 5 deal with the organization, independence, powers, jurisdiction and procedures of the Supreme Court. Okay. So, the Parliament is also authorized to regulate them. Now, before going into the topic, removal of the Judge of Supreme Court, let us try to understand the judicial system. So, Indian Constitution has established what type of judiciary, whether it's a unified judiciary or integrated judiciary or double system of courts. Let us try to find out. So, Indian Constitution has established a integrated judicial system. Now, what is integrated judicial system? So, integrated judicial system with the Supreme Court at the top and High Court below it. Supreme Court at the top and High Court below it. Under the High Court, that is below the state level, you have subordinate or other courts. Subordinate or other courts. So, these courts, they enforce both central as well as state laws. That is, you have single set of courts, unified integrated judiciary, which enforce both center and state laws. Now, what about the American judiciary? The American judiciary, unlike the Indian or the American Constitution, establishes double system of courts. Double system of courts. Now, what is double system of courts? That is, you have federal judiciary and state judiciary. So, the federal judiciary enforces the federal laws, state judiciary enforces the state laws. That is, there are two sets of courts, one set dealing with the enforcement of the federal laws, that is federal judiciary, and the other set dealing with the enforcement of the state laws, that is state judiciary. So, American Constitution established double system of courts. That is, unlike the American Constitution, we have already learned, the Indian Constitution establishes integrated judicial system. So the Indian system or Indian polity, although it is federal in structure, you have unified judiciary, that is integrated judiciary, and also you have one system or single system or one system of fundamental law and justice. Okay. So, this is about the Indian judicial system. That is, though like the American polity, our polity is also federal in structure. Okay. Still, our judiciary is unified judiciary, but whereas American judiciary is double system of courts. So, Indian judiciary has one system of fundamental law and justice. Now, what is the strength of the Supreme Court? Okay, originally the strength of the Supreme Court was fixed at 8, including the CJI, that is 1 CJI plus 7 other judges. The Parliament has progressively increased the number of judges progressively. So, now at present the strength of the Supreme Court is 34, including the CJI, that is 1 CJI plus 33. In the year 2019, the center has notified the increase in number of judges of the Supreme Court from 31 to 34. Okay, so this followed the enactment of Supreme Court number of judges Amendment Act 2019. Okay, so now the present strength is 34. That is, in 2019, Center has notified for an increase in the number of judges of the Supreme Court from 31 to 34. This was followed by an enactment, that is Supreme Court Number of Judges Amendment Act 2019. Okay, so now having understood the strength, now let us talk about the tenure. Is the tenure of the judge of the Supreme Court fixed by the Constitution? No, the Constitution has not fixed the tenure of the judge of the Supreme Court, but it has made 3 provisions. So what are these 3 provisions? That is, he holds the office till he attains the age of 65 years. And any question regarding the age is determined by such authority and in such manner as provided by the Parliament. This is the first provision. That is, the judge of the Supreme Court holds office until he attains the age of 65 years, and any question regarding the age is determined by such authority and in such manner as provided by the Parliament. Now, what about resignation? Is there any provision of resignation? Yes. The judge of the Supreme Court can resign his office by writing to the President. Okay, so there is a provision for resignation also. Now, what about removal? Is there any provision? Yes. Removal. The judge of the Supreme Court can be removed by the President on the recommendation of the Parliament. Okay. So the Constitution has not fixed the tenure of the judge of the Supreme Court. It has made 3 provisions. Okay. First one, he holds office. The judge of the Supreme Court holds office until he attains the age of 65 years. And any question regarding the age is determined by such authority and in such manner as provided by the Parliament. And resignation, he can resign his office by writing to the President. And removal, he can be removed by the President on the recommendation of the Parliament. So, now about the removal, now already we have understood that he can be removed by the President. Okay, so the President, the judge of the Supreme Court, can be removed by the order of the President. The President can issue a removal order only after an address only after an address of the Parliament has been presented to him in the same session of a Parliament. Okay, so the judge of the Supreme Court can be removed by the order of the President, and the President can issue the removal order only after an address of the Parliament has been presented to him in the same session. This address has to be supported by each house by special majority. Now, special majority. What is special majority? Special majority is absolute majority that is majority of the total membership of that house plus majority of at least 2/3 of the members present and voting of that house. That is special majority. Special majority is absolute majority, that is majority of the total membership of that house, and majority of at least 2/3 of the members present and voting of that house. So, the address has to be supported by special majority of both the houses. Now, are there any grounds mentioned in the Constitution for the removal of the judge of the Supreme Court? Yes, there are two grounds. Okay, what are they? Crude misbehavior and incapacity. Crude behavior and incapacity. So, these are the grounds mentioned in the Constitution for the removal of the judge of the Supreme Court. Now, what about the procedure? The procedure for removal of the judge is regulated by the Judges Enquiry Act. Of 1968 by the process of impeachment. So, how can a judge of the Supreme Court be removed? By the process of impeachment, and the procedure has been regulated by the Judges Enquiry Act 1960. So, let us now try to understand what is the procedure. Okay, so procedure. The removal motion signed by 100 members. 100 members in case of Lok Sabha and 50 members in case of Rajya Sabha has to be submitted to the Speaker and Chairman respectively. Okay, the removal motion signed by 100 members in case of Lok Sabha and 50 members in case of Rajya Sabha has to be submitted to the Speaker or Chairman. The Speaker or Chairman may admit or refuse to admit the removal motion. In case the Speaker or Chairman admits the removal motion, a three-member committee is to be constituted for this purpose. Okay. So, what is the composition of the three-member committee? The composition of the three-member committee is Chief Justice of India or Judge of Supreme Court, Judge of Chief Justice of High Court and a distinguished jurist. Okay, so the composition of the 3-member inquiry committee is Chief Justice of India or Judge of the Supreme Court and Chief Justice of the High Court and a distinguished jurist. Okay, so if the 3-member committee after the inquiry finds the judge to be guilty of misbehavior or incapacity, then the House may take up the consideration of the motion. Take up for consideration of the motion. Okay. So this motion, the motion has to be passed by each house by special majority. We have already discussed what is special majority. That is absolute majority of the total membership of that house plus majority of at least 2/3 of the members present, and voting of that house. So the motion has to be passed by each house by special majority. After passing, the address of the parliament has to be presented to the president. Address of the parliament has to be presented to the president in the same session. Then the president issues a removal order. So the judge of the Supreme Court stands impeached. Okay. So a quick recap about the procedure. The removal motion has to be signed by 100 members in case of Rajya Sabha, Lok Sabha, and 50 members in case of Rajya Sabha. Has to be submitted to the speaker or chairman. The speaker or chairman may admit or refuse to admit the removal motion. In case the speaker or the chairman admits the removal motion, a 3-member inquiry committee has to be constituted for this purpose. The composition of the 3-member inquiry committee consists of the Chief Justice of India or Judge of Supreme Court, Chief Justice of High Court and a distinguished jurist. If the committee on inquiry finds the judge to be guilty of misbehavior or incapacity, then the House can take up for consideration the motion. The motion has to be passed by each house by special majority. We have already talked about special majority, and now after the motion has been passed by each house, an address of the parliament has to be presented to the president in the same session for his removal. And after receiving the address, the president issues a removal order and the judge of the Supreme Court stands impeached. It is interesting to know that so far no judge of the Supreme Court has been impeached. The first such case is of Justice V. Ramaswamy, 1991-93, Judge of the Supreme Court. The inquiry committee found him guilty of misbehavior, but the impeachment motion was not passed because the Congress party has abstained from voting. So this is the process for removal of the judge of the Supreme Court. Now what about the process for the removal of the judge of the High Court? Article 214 to 231, Part 6 deals with the High Court, that is the organization, independence, power, jurisdiction and procedure, so on. So it deals with the High Court. So the procedure for the removal of the judge of the High Court is same as the judge of the Supreme Court. So This is about the process of removal of the judge of Supreme Court. Thank you.